allow it. Allow it so far.
Thank you. Thank you. Okay. So what I'm going to do is go through some of these statements, and I'm going to be asking you if these are consistent with the standards of practice for prosecutors in North Carolina to make statements like the ones we're going to go through. And the first one is, quote, "And one would wonder why one needs an attorney if one was not charged and had not done anything wrong." And the next one I'd like to ask you about is, well, frankly, quote, "Well, frankly, I'm disappointed. I understand that it's likely they're doing it as a result of the advice of counsel, but although that might be good legal advice, I don't think it's good moral advice," end quote. Are those statements consistent with the standard of practice for prosecutors communicating with the media in North Carolina?
No, ma'am.
And how do they deviate from the standard?
The rules specifically prohibit us in talking about one's exercise of the rights to counsel, which under the Sixth Amendment, and their right to remain silent under the Fifth Amendment. And I believe, once again, one of the rules directly says that we cannot comment on whether or not a defendant did or did not make a statement. If you were at trial in a closing argument, so to speak, talk about how the law or the defendant did not make a statement because he either chose to remain silent or he asked for a lawyer, that's grounds for a mistrial. So you can't even say it in court in front of the jury, and if you can't say it there, you certainly can't say it outside the courtroom.
But why can't you say it outside the courtroom? What's the harm?
Because you're commenting on their exercise of their constitutional rights.